The terms cessation of payment and inability or disturbance in the debtor's financial position under the UAE financial restructuring and bankruptcy law. This presentation will provide an in-depth analysis of the key criteria defined in the UAE Financial Reorganization and Bankruptcy Law No. 51 of 2023, hereinafter referred to as the law or bankruptcy law. The focus will be on the law's provisions concerning cessation of payment and inability or disturbance in the debtor's financial position, as these terms play a critical role in determining when proceedings can be initiated. A clear understanding of these terms is essential to establish when a debtor or creditor may file a petition with a competent court under the law. Therefore, we need to compare these terms or standards and how they are applied, given their importance in the law. This is particularly important as it will determine how easily the debtor or creditor can file a request to initiate proceedings. Key terms in the bankruptcy law. The presentation begins with the definition of a debtor under the bankruptcy law, which encompasses both natural and legal persons. The law stipulates that in order to request the opening of preventive settlement, restructuring, or bankruptcy declaration procedures, the debtor must be in one of the following conditions: 1. Cessation of payment, or 2. Inability or disturbance in the debtor's financial position. This presentation will examine both conditions and highlight the differences between them. Cessation of paying debts. This is a key term in bankruptcy law, serving as the primary criterion for identifying insolvency. When this situation occurs, bankruptcy law is invoked to deal with the debtor's challenging financial situation, protect creditors' rights, and determine appropriate methods for settling debts based on the debtor's specific circumstances. The law offers a specific definition for cessation of payment. According to the law, a debtor is deemed to have ceased payment if they fail to settle a due debt. After 10 days have passed after the expiration of a notice period, even if their assets are sufficient to cover the debt or if it is secured by guarantees, it becomes evident that if a debtor fails to pay a due debt, then receiving a notice specifying a time frame for payment, and then the passage of 10 days since the end of that period without settling the debt, here the debtor may be considered in default under the provisions of the law. For example, if debtor A owes creditor B $500,000 due on 10 October 2024 and fails to pay by that date, creditor B may issue a formal notice on 10 November 2024, giving the debtor 15 days to make the payment. If 15 days elapse and the debt remain unpaid, followed by an additional 10 days, the situation qualifies as a cessation of payment under the law. However, to initiate any insolvency proceedings, whether it be preventive settlement, restructuring, or bankruptcy declaration, additional conditions must be met, which will be addressed according to each specific case. Inability or disturbance in the financial position. Next, we examine the debtor's inability or disturbance in financial position as stated in the definition of the debtor. This term is crucial for determining the mechanisms and standards required to initiate legal procedures, and it differs from the concept of cessation of payment. When reviewing the definitions provided in the law, we find that while the term disturbance in the debtor's financial position is clearly defined, the law does not specifically define debtor's financial inability, despite the latter being more frequently referenced in the articles of the law. The law defines disturbance in the debtor financial position as follows. The debtor either stops paying debts as they come due or anticipates being unable to pay them within 3 months due to instability in their financial status or a disruption in their financial situation. This definition contains 2 main parts. The first part relates to a default on a debt that is due for payment. This condition mirrors international standards such as the cash flow test for bankruptcy, where a debtor is insolvent due to insufficient liquidity. In this situation, the debtor should assess its current obligations and upcoming liabilities. The second part of the definition addresses the debtor's anticipation of being unable to pay debts within 3 months due to instability or disturbance in their financial situation. It is clear that the second part of the definition, referring to the anticipation of inability to pay, has been linked to 2 issues. First, the anticipation of inability to pay must occur within a specified time frame of 3 months. However, the law does not clarify when this 3-month period begins, whether it begins from the date the debt is due and remains unpaid, or from the date of the debtor's notice of the obligation to pay. This anticipation arises from an instability or disruption in the debtor's financial situation. But this raises a question. Is there a distinction between an instability and disruption in the financial position or situation? Both terms seem to point to the same outcome, a state of inability to meet the debtor's expected financial obligations. This scenario usually occurs when the debtor's liabilities exceed the value of their assets, that is, when the debtor lacks sufficient assets to cover their debts. Thus, the definition of disturbance of the debtor's financial position encompasses both scenarios, where payment has already ceased and where there is an expectation that the debtor will be unable to pay within 3 months due to financial instability or disruption. In either case, the debtor is deemed insolvent. The legal term unable to pay presents a challenge for non-debtors, particularly creditors, in accurately assessing a debtor's financial position. This is particularly notable in that the law does not impose an obligation on managers or debtors of the debtor to initiate insolvency proceedings upon becoming aware of financial difficulties. Consequently, it may be challenging in practice to foresee insolvency within the stipulated 3-month period, potentially leading to increased debt and ultimately rendering the debtor's bankruptcy and asset liquidation inevitable. Another key point in comparing the definitions of cessation of payment and financial disturbance is that under bankruptcy law, cessation of payment does not require the cessation to stem from a disturbance in the debtor's financial position. The law permits a cessation of payment regardless of the debtor's financial condition, even if the debtor possesses sufficient assets to cover their liabilities or if the unpaid debt is secured by adequate guarantees. This differs from what is followed in most comparative laws. Insolvency procedures, regardless of their type, should not be viewed simply as a tool for debt collection. Instead, they serve as a mechanism to safeguard the overall economy by protecting the interests of both creditors and the insolvent debtor. Next, we will examine how the terms cessation of payment and disturbance of the debtor's financial position are applied within the procedures prescribed by law. We begin with Article 15, which establishes the general rule permitting the debtor to request the initiation of procedures, irrespective of the type, whether preventive settlement, restructuring, or bankruptcy declaration. The law grants the debtor the right to submit this request within 60 days from the date of cessation of payment. Essentially, the debtor has a 60-day window to submit a request for the initiation of procedures after the cessation of payment, in addition to the timeframes related to the payment notice. Once a payment notice is issued with a deadline, for example 15 days, and if no payment is made within an additional 10 days, the cessation of payment is deemed to have occurred. From that point, the debtor has an additional 60 days to submit a request for preventive settlement, restructuring, or bankruptcy declaration. Furthermore, paragraph 1 of Article 15 does not use the term disturbance of the debtor's financial position, as defined in Article 1 of the law. Instead, it uses the phrase inability to pay debts when due, giving the debtor 60 days to submit a request to initiate procedures from the date they become aware they will be unable to pay their debts on time. As previously explained, this depends on the debtor's assessment and knowledge of their financial situation, without requiring the debtor's managers to immediately submit the request upon learning of it, nor holding them personally liable if they fail to do so. Article 16 of the law addresses the right of a creditor or group of creditors to submit a request to initiate restructuring or bankruptcy procedures. A creditor or group of creditors may submit such a request if certain conditions are met, such as the debt being unconditional, undisputed, due for payment, and meeting the minimum amount specified in the executive regulations of the law. The request may be filed if the debtor has ceased making payments, that is, after the issuance of a notice, the expiration of the specified period therein, and an additional 10 days have elapsed. The law further requires that the creditor must have served a notice to the debtor for payment, and if the debtor fails to do so within 30 days of receiving the notice, the creditor may submit the request. The conclusion drawn from this presentation is that this is still a new law, and it will take some time for it to be actually tested by the commercial community and for the courts to issue decisions to interpret its various provisions in practice, so that we can become familiar with the provisions of the law and its method of determining the timing and status at which the debtor and creditor may initiate the procedures, and I see that this is not an easy matter at present. Next presentations. Personal liability of directors, managers, or any person responsible for the actual management of the company, navigating contracts and obligations. During debtor restructuring or bankruptcy. Protecting the rights of the secured creditors during financial restructuring and bankruptcy proceedings. How a court may decide on the viability of a debtor.